Hey there gang, Jim Hart here today, and today I want to talk to you a little bit about contributory negligence. And you're probably wondering what contributory negligence is. Well, if you are injured in an accident of some sort, whether it be a car crash or one thing that happened over the holiday week, I guess you call it the week, is I went to a fair. A lot of you probably went to fairs and did things, went to fireworks shows and things like that. Well, there were a lot of people there, and I'm confident, I can say this with a great deal of confidence, that there probably were some accidents that occurred at that fair because of the drinking involved and the crowds and the number of just idiotic people I saw. This, if you were injured in something like that, or maybe perhaps riding a fair ride or things like that, contributory negligence is something that you need to understand, and especially if the accident happened in North Carolina. Now, I was in Ohio, and so Ohio has a different set of rules. I'm not licensed in Ohio. I don't know what the rules are in Ohio. But this is what you need to know. So basically what contributory negligence says, and this is in North Carolina. North Carolina is one of only 4 states that have this rule, and the District of Columbia. The other states are Virginia, Maryland, and Alabama, I believe. And basically what this rule says, it says that if you were even 1% at fault in causing the accident or causing your injuries, then you don't recover, nothing at all. So if you sue somebody, you sue a defendant, and let's say that they assert this defense for contributory negligence, and a jury finds that you were 1% at fault for the injuries that you sustained, then in that case you're not going to recover anything. I realize this sounds completely draconian and completely unfair. In a lot of respects it is. We can thank the insurance lobby for giving us rules like this, but that is the rule right now in North Carolina. So if you're out there and you're driving, it's still kind of July 4th weekend, be careful, be safe. Today it's kind of a rainy day here, and you just need to exercise proper care. And if you do that, then you don't need to worry about this rule. You know, when we're representing people that have been injured, if they come to us and they were acting prudent and normal and as like any reasonable person would be, then they weren't being negligent. They were following the rules. They're following the speed limit. They were following a safe distance behind the person in front of them. All these things. You don't need to worry about contributory negligence if you were doing all the right things. But if you were, if you were jaywalking, if you were drinking too much while you were driving, even if you didn't really cause the accident, that's going to be a problem. If you're driving too slow in a speed limit, I saw this. I was driving when we were driving back from Ohio yesterday, and a bunch of cars in front of us broke or put on their brake lights really fast because there was a car ahead of them that was driving too slow. The speed limit was 70 miles an hour, and they were driving 45 miles an hour. That was too slow. They could have been considered contributory negligence. So all those things can have an effect, and but just be safe. Be out there, be safe, do the right thing, and you don't have anything to worry about. So that's it for today. I'm going to try and do more of these videos on Instagram TV, and I hope you enjoy. I'll try and give legal tips about a number of different things, from family law to personal injury to wills and trust, elder law, and different things like that. And just I'm trying to give a lot of information and be helpful. If you know of somebody that you think might enjoy this, feel free to share this video. And thank you so much today. Have a great day, folks, and don't forget to subscribe. Take care.